All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, it shall be heard. God save the United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on today's docket is the Florida Bar versus Payne.
May it please the court, my name is Martin Payne. I'm representing myself in this proceeding. I've been a member of the Florida Bar since 1985, and during that 35-year period, up to and including today, no client or any other member of the public has complained to the Florida Bar about my conduct. I have a small transactional practice, and I've not only not had any complaints, but also not a single title claim in 35 years. I've learned a lot about the Florida Bar disciplinary system over the last couple of years. I've learned that like any large organization, they are only as good as the systems they have in place and the individuals that operate within that system. I also learned that they make mistakes. The first mistake by the Florida Bar is that for almost a year of this process, they mistook my identity for a different person with a similar name. Well, after my deposition, probable cause, and the pleadings, we were assigned Judge Coleman as the referee, and he scheduled a conference. At that time, he informed us that he had been assigned this case as the referee because he had previously handled my case, my Florida Bar disciplinary case related to my criminal conviction for battery on my spouse. I said, "Your Honor, that was not me. That is a different person." And he looked at me and he said, "Yeah, it was not you." After the conference, I asked Matt Flicka, then Florida Bar counsel, who's now left the bar and went to work for the firm that his star witness was working for, but we'll get into that later. I asked him if he knew they had the wrong guy, and did that affect anything in opening this matter or moving it forward. He just shrugged. When I got back to the office, I called the Florida Bar and I asked for a supervisor. And Adria Quintella called me back, and I asked her if this had any impact on opening this matter or moving anything forward. She said it was irrelevant. She also is no longer with the Florida Bar. I can assure you that it matters that a person is mistaken for someone who has criminally assaulted, has a criminal record for criminally assaulting his wife, when that is simply not me.
Counsel, and you know, we're here on specific charges that have been adjudicated, and the recommendation based on those. And you can proceed however you want, but I think you're better to focus on why you think the specific charges are not supported by the record, and otherwise focused on what we specifically have before us.
It's a pattern, Your Honor, that didn't appear until after the trial. The week before the trial, the witness leaves her job where I allege she has created evidence. The week after the trial, Mr. Flicker, who essentially wrote the proposed report of referee, which was 95% adopted by Judge Coleman, so the person that essentially wrote the report of referee leaves the Florida Bar as well.
For example, do you contest that you directly solicited a client in contravention of the solicitation rules that govern attorney conduct?
Yes, I did not solicit a client. At that time, we contacted the people as an investor, and I was one of 8 people in an investor group. I didn't start representing the client until probably about a month later. So no, I did not ever solicit anybody. The Florida Bar rules don't exist in a vacuum. They only exist if people that have the knowledge of actually what happened here in processing a short sale. And at some point in the process, Mr. Gilks, who was in huge financial distress, asked if I could represent him on the short sale. And the reason he did that is because he had purchased the property at a short sale and he knew it was possible. These people had $398,000 in student loans. They had a car repossessed. They had no chance of getting out of this situation. I could have said, "Hey, no, I'm not going to represent you." But I said, "Yeah, I'll take on your case," because it's the very type of people that the Florida Bar for 35 years said that we should try to represent.
So your your real estate investment firm that you're an owner in purchased the lien rights and foreclosed on the property that the person owned, is that correct?
Yes, we purchased property at auction. And then we reached out to them to see if they wanted us to help reinstate their mortgage and work with them to try to sell the property and make a profit that way. When that became not realistic, there was no equity in the property, then he asked me if I would represent him. And at that point I said yes. But initially I didn't reach out to him to be his attorney. I do virtually no litigation. And the only litigation was done in this matter was to hold off the foreclosure, which you're entitled to do under the Dodd-Frank rule against dual tracking, in order for the short sale to proceed. I think that if you take a look at this trial.
So you didn't make any filings in court before you had a relationship representing the individual you're talking about?
Correct. We discussed that the very first thing I filed was a motion to get the reinstatement, which was to find out if there was equity in the property or not.
Was there an attorney-client relationship then?
When I filed the document, yes. And he said as much in his deposition.
So what's the explanation for the September 2016 letter where they said after the filings had been made that you in fact weren't their lawyer?
The initial document was because this is a young couple who was extremely scared. So he looked at the court document. What it said was that someone filed the document. It was actually the opposing counsel, but it was a non-military affidavit, which is fairly standard in a foreclosure proceeding. He thought that it was a military affidavit, and he said he and Nicole had never been in the military, and that's what that letter says. And how this started was 11 months after that, well into the short sale representation, Helen Scala goes before Judge Cook and says, I don't represent Mr. and Mrs. Gilks, when for 11 months we had worked together on the short sale. In fact, she had required at some point that every document go straight to her and then to Wells Fargo and back to her and back to us, a situation I'd never ever had before or since on a short sale. So yes, he did do that letter. He retracted that letter many, many times. And one of the rule violations that I think, let's go back to the trial in this situation. What you have is it's not a trial like I'd ever seen before or like you'd think. There's no this big finding of fact. What it is Mr. Flicker comes in and he hands the matching trial notebook. And they flip through this trial notebook in chambers about 2 feet apart in rapid fire succession. And I've tried to object, because it's just nonsense. With no understanding of what happened, the questions are not relevant to the rules. And so they said this is not criminal. Referee Coleman said this is not criminal. This is not civil. It's quasi-judicial, and I'm letting everything in, even hearsay. I objected again. And, they're just throwing in documents, basically just as fast as you could fill out forms and put them in the record. That's how fast this thing went. The second time I objected, he said if I did it again, he was going to have me removed from chambers. So I sat there, and for 35 minutes, I watched a 35-year career go down the tubes with nonsense from someone who had never closed a real estate transaction.
When you say chambers, are you talking about this hearing being conducted in open court or back in the judge's office?
In the judge's office.
In the judge's office.
Yep. And he said, right, they're literally, the matching notebooks couldn't have been 2 feet apart, and they just flipped through them as fast as you could flip through them with no opportunity to object. And he said, you'll get your chance, and I'll let everything in that you have too. So this whole idea that there's this vetting of evidence or anything like that, it simply didn't happen in this case. And this court has said,
are you saying you were denied a right to testify or present whatever evidence you wanted?
No, I was able to testify, and to present the evidence I wanted. In fact, even my wife testified, and Judge Coleman was looking out the window the entire time. But yes, I was allowed to present that, and they just put everything in. But if you're looking to check the boxes of the rules, the elements or whatever of the rules violations, here's the most absurd one: communication. That I somehow failed to communicate. For a year and a half, every single email Armando Gilks was on. We talked by phone, we communicated by text, we communicated by email. I have daughters older than his. I know we talked a lot about parenting. I talked with him over and over. You can't communicate any better with the client than I did with this client, especially in lieu of that very first letter. I made sure. and yet they said that somehow I failed to communicate, which is normally like if you miss a hearing or you miss a filing or something like that.
Is it your contention that there was no conflict of interest?
If I had to do one thing over again, I would not submit the first contract with myself being the president of the company.
So you recognize that there was a conflict of interest and you did not get a waiver?
I don't believe that you can have a conflict of interest in a short sale because the party that you're dealing with is the lender, is who the seller of the property is, and it was not my client. But in abundance of caution, as soon as that was pointed out, I immediately withdrew that contract, submitted a new contract that I had no financial interest in whatsoever, and I said, there's no need to quitclaim the property because, a lot of times in real estate, it comes in and the husband and wife are on the property, but only the wife's going to sell or it's in a probate. So he changed the entity right before closing. They said, no, we want you to give the property back to the Gilks now. I talked to my investors. They said, fine. So we gave the property back to the investors now. So we corrected, I believe.
When you take off your attorney hat and put back on your real estate investing hat, when you approached the Gilks originally, I understand it wasn't to represent them. You're saying it really was to try to get the property, correct?
We already had the property. We purchased the property at auction.
Well,
so we reached out to try to help them.
To deal with the first mortgage. Correct. To get it without that first mortgage, because there was no...
To work on paying off or...
Right, so you were representing your own interests, the interest of your real estate investing firm, in trying to work this out so that you could get rid of the first mortgage and the property that you had acquired, correct?
Ultimately, yeah, either to at some point get rid of which we could do without the Gilks as well. We could, if we were just trying to help them. So, but the whole point of the disciplinary proceeding is Florida Bar versus Payne is the protection of the public, and in this situation, the public is entirely missing. There is nobody from the public that appeared. In fact, Mr. Flicker in open court stated, quote, "To my knowledge, the bar has not spoken to anyone at Wells Fargo or USDA. I personally have not, Your Honor."
So you didn't need to speak with him in order to advance your personal interests in trying to get rid of the first mortgage and the property that you had acquired. I thought that's why you said you contacted them originally.
Originally, we contacted them to see what the value, what the amount was of the first mortgage. That was what was contacted. That was the first thing we needed to find out was what was the outstanding balance on the first mortgage. That's why we contacted them. But then after a period of time, when that didn't work, he asked me if I would represent him in a short sale, and I agreed. So my position is that we always had the best interests of USDA, Wells Fargo, and the Gilks in mind. Everything was done for that benefit, and there's nothing that I don't believe that shows to the contrary. But along this way, at some point, the short sale approval letters, when you go to apply for a loan,
Counsel, you can keep going, but you now are in your rebuttal time. So if you want to reserve some time,
I'll reserve time, Your Honor.
Okay.
May it please the court, my name is Lindsay Ganand and I am counsel for the Florida Bar. Mr. Payne engaged in egregious cumulative misconduct over a 2-year period, and he did so for the interests of himself and his company. The record is clear that Mr. Payne directly solicited clients and made no less than 11 misrepresentations to those clients, to opposing counsel, and to the court. And I would like to bring to this court's attention a misrepresentation that Mr. Payne made to you today. When Justice Lawson asked, "Did you contest that you directly solicited a client?" Mr. Payne said, "Yes, I do. I reached out to them originally as an investor, and I did not represent them until approximately a month later." That is inconsistent with his testimony and the filings that he filed in that foreclosure matter. He purchased the property on August 19th, and he filed his motion to compel for reinstatement on August 25th, 6 days later, not a month later. So already there's contradictory evidence in front of this court. There were at least 11 misrepresentations made throughout the entirety of this 2 years. The referee in the matter found his conduct to be deceitful and dishonest, evaluated the credibility of Mr. Payne. and based on that conduct, applied the standards and the case law and determined that disbarment was the appropriate sanction. The bar supports the referee's recommendation and asks this court to adopt that, the referee's recommendation of disbarment.
Can you, I couldn't understand what was going on with the letters from the clients, first saying that the respondent wasn't representing them and then later saying something different. Can you explain that?
Yes, Your Honor. So the first letter, which was in September, approximately a month after Mr. Payne purchased their property, saying that there were filings in the foreclosure matter that they did not authorize, they had not hired counsel, they had not signed a retainer agreement, and they did not agree with the filings, particularly the motion to compel reinstatement. Approximately a month to 2 months later, they did sign and file an affidavit with the court that was drafted by Mr. Payne, saying that he was representing them, dating all the way back to August of 2016. But if you review the record in Mr. Gilk's testimony for the court in his deposition, he says he doesn't really think of representation in the legal sense. The reason he agreed to sign that affidavit was that he agrees now that Mr. Payne was acting in their best interest. Not that they agreed to the representation, and the word representation that Mr. Payne put in the affidavit, but that they think in hindsight he was trying to do good for them back in August of 2016, so he felt comfortable signing an affidavit drafted by Mr. Payne that said they were being represented that entire time. The referee did, in the report specifically said that he determined that was due to the insistence of Mr. Payne, and if you review the emails which are in evidence, you can see Mr. Payne's email to the Gilks saying, your case, the foreclosure case, you're going to be defaulted and your house is going to be foreclosed upon if you do not correct this and tell the judge that I represent you. Here's an affidavit to sign, which they did and then filed. The referee determined that the Gilks testimony that they were not represented in that pro se letter was the most credible at that time. There are 3 cases, Your Honors, that do support a finding of disbarment in this case. That would be the Florida Bar versus Klein and the Florida Bar versus Carresco, which were cited in the report of referee, as well as the Florida Bar versus Kane, which was cited in Mr. Payne's initial brief. In all 3 of those cases, this court disbarred respondents for engaging in conflict of interest and misrepresentation, and they did so when the respondents had no prior discipline, the same as Mr. Payne. The referee's report is based on competent, substantial evidence. All of the findings are based on competent, substantial evidence, and the sanction is reasonably supported by the case law and the standards. Mr. Payne has failed to show that either one of those are in error, and for that reason we ask that you accept the referee's recommendations in his entire report. If there are no other questions, thank you.
For almost a year, the Florida Bar thought they were prosecuting a different person with a similar name. So what impact that mistake had on my life, we may never know. After trial and the writing of the proposed report of referee, which was largely adopted, Mr. Flicker wrote that report. We asked us each after the thing just to submit our proposed. I submitted my proposed report. He submitted his proposed report. He took his almost verbatim. So this whole idea that Referee Coleman made that the Florida Bar has immense power, and that's who wrote the report of referee. But that person, I believe, was who was with the Florida Bar for a relatively short, little over 2 years, and is no longer with the report. I think every file he touched probably should be reviewed at this point.
Sir, I'm sorry for interrupting you, but do you have a response to what opposing counsel said about the fact that essentially the record contradicts something that you just told us about the 2 months in between the first contact and the representation?
So the I don't have the date. We purchased property in August, and in September was the first motion that we filed on to find out what was the amount of the outstanding amount of the mortgage. So I don't think there's any contradiction at all.
She said that it was 6 days later that you filed that, and you told us that it was a couple of months or a month or more.
I don't think it was 6 days later. 6 days. The certificate of title may came out at some point, but the auction itself was farther back in August, and there was a time gap where at one point that we had my investor hat on, and then it switched over when he asked me to represent him in the short sale later on. So the last thing is when you apply for a loan, and we proceeded all the way down to getting the short sale approved. We allege that Helen Schuyler, she said that, so we've spent 7 months putting all the documents in, and then Wells Fargo says, we have all the documents we need, we're getting ready to make a decision on this loan. And then this is the only witness that the Florida Bar had at trial. Everything else was just documents they just pieced together. Because initially when they said I didn't represent him, I sent them 700 pages. I said, I got nothing to hide. Here's everything. Here's every note. Here's every email. Here's everything. And they pieced and parsed all that together and tried to come up with something that showed that the situation was worse than it was. So the last thing is that the case of Shrew says that the disbarment is the same penalty as the same wrong as the death penalty. And I think that the action in this case and the conduct in no way rises to that level. And we'd ask this court to reverse the decision and then the alternative to reduce the penalty to a short suspension. Thank you.
Right. We thank you both for your arguments. We now move to the second case on today's docket, which is the state of Florida versus Marsh.
Good morning. Hey, good to meet you.